viewers, welcome to our channel Basics on Law and Jury. From this channel, we will get some ideas on different types of laws and definitely have some ideas how does law can help to the people in their daily lives relating to different cases like injury cases, accident cases, etc. So friends, without wasting any time, let's go to our new video and let's see what we can learn from this video. If you like this video, please subscribe our channel and give like to our channel. And don't forget to press the bell notification so that when our new video will releases, you will get the notification first. So let's see what we can learn from this video.
Property law. Your questions answered. What are three different types of property law? Private property, collective property, public property. What is meant by property law? Property, an object of legal rights, which embraces possessions or wealth collectively, frequently with strong connotations of individual ownership. In law, the term refers to the complex of dual relationships between and among persons with respect to things. What kind of law is property law? Property law is primarily state law, but there may be constitutional challenges or federal government ownership issues involved in property law. Property lawyers generally work throughout the United States. They generally practice transactional law, but they must be prepared for litigation if their case goes to court. Why is property law important? Property rights provide the owner with the legal ownership of a resource. This is backed and enforced by the legal system as well as the protections government provides through law and order. For businesses, this means that they have the right to use their capital to produce goods without fear of loss. What is land property law? Land law is the form of law that deals with the rights to use, alienate, or exclude others from land. In many jurisdictions, these kinds of property are referred to as real estate or real property, as distinct from personal property. What's a property lawyer called? In addition to hiring a real estate agent to help negotiate the transaction, you might consider a real estate lawyer to guide you through the legal process. Real estate attorneys specialize in matters related to property, from transactions to handling disputes between parties. Why is property law so hard? Property law is the hardest subject for a lot of folks because it uses some of the most archaic terms and convoluted rules of any legal subject area most lawyers are forced to study in law school and for the bar. Who is the legal owner of a property? The legal owner of a property is the person who owns the legal title of the land, whereas the beneficial owner is the person who is entitled to the benefits of the property. What are the four property rights? The main legal property rights are the right of possession, the right of control, the right of exclusion, the right to derive income, and the right of disposition. There are exceptions to these rights, and property owners have obligations as well as rights. How many sections are there in property law? There are 137 sections in the Transfer of Property Act. Is property law and land law the same? Land law is part of property law, where property can be defined in this context as the condition of being owned by way of a legal relationship. Land is known as real property. What are property types? There are 5 main categories of real estate: residential, commercial, industrial, raw land, and special use. You can invest in real estate directly by purchasing a home, rental property, or other property, or indirectly through a real estate investment trust, REIT. What are the 2 main types of property? Real and personal property overview. There are 2 basic categories of property, real and personal. The assessment procedures and the tax rate will vary between these 2 categories. Real property, in general, is land and anything permanently affixed to land, e.g. wells or buildings. How do you get into property law? How to become a property lawyer. Complete a qualifying law degree or non-law degree followed by the graduate diploma in law. Complete the legal practice course training contract, or the solicitor's qualifying exam post 2021. What makes a good property lawyer? To be successful as a property lawyer, you'll need attention to detail and the ability to meticulously collate and present information. Your drafting skills should be first class and you'll need to have a thorough understanding of the various laws and regulations that govern property. Is property law interesting? Arguably the most relatable for all, the area of property law affects every individual in society, whether that be those renting, or those investing in large-scale property projects. What is ownership in land law? Proof of land ownership is how one claims the right to land. It is the protection and degree of control a person has over a parcel of land. Do real estate lawyers go to court? Real estate lawyers represent their clients in real estate litigation. This includes drafting legal pleadings to file with the judge, participating in hearings and trial with the judge, and filing appeals if necessary.
She's waiting for love to be realized. I'll send her my heart covered as a gift, and hope that you'll take it into her side. La 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 la.
What is law school property? Property, 217. It deals with possession and ownership of land and with the incidents thereof, including private and public restrictions on its use and development, nuisance, trespass, concurrent interests, landlord and tenant, and eminent domain. Is real property law hard? Real property is one of the hardest core subjects in law. Can a property have two owners? Under a co-ownership, the ownership of an undivided thing or right belongs to different persons. Each co-owner of property which is held pro indiviso exercises his rights over the whole property and may use and enjoy the same with no other limitation than that he shall not injure the interest of his co-owners. How many legal owners can a property have? 4 people. Up to 4 people can be named as legal owners. If there are more than 4 owners, then ownership is through the device of a trust. The additional owners, and there can be any number, can be named as beneficiaries of the resulting trust for sale. Can I claim ownership of land? Generally speaking, if you have been occupying lands that you do not own, rent or otherwise have permission to use in excess of 12 years, or in the case of crown lands 30 years, without any objection from the registered owner, you can claim what is known as adverse possession. What determines ownership of a property? Each owner has the right to occupy and use the entire property. The interest percentage simply determines the financial ownership of the real estate. Unlike joint tenancy, tenants in common hold title individually for their respective portion of the property and can dispose of or encumber it at will. Who can transfer property? One who is absolute owner of the property and property is free from encumbrances is capable to transfer the same. An owner of the property may authorize his power of attorney holder to transfer the property for him and on his behalf. What does a property lawyer do? Property lawyers help clients deal with a wide range of property-related issues including buying, selling, subdividing, transferring titles, council and building restrictions, tax implications, approval processes, and restrictive covenants and easements. What is property easement? An easement is a real estate ownership right, an encumbrance on the title, granted to an individual or entity to make a limited, but typically indefinite, use of the land of another. Easement owners have a legal right to maintain the easement and have a legal right of access across the easement. What is common law property rights? Common law property is a system that most states use to determine the ownership of property, particularly in cases of divorce. Under a common law property system, assets acquired by one member of a married couple are deemed to belong to that person, unless they were put in the names of both. What are 4 examples of properties? Familiar examples of physical properties include density, color, hardness, melting and boiling points, and electrical conductivity. We can observe some physical properties, such as density and color, without changing the physical state of the matter observed. What are the 3 types of land? 3 different types of land for sale you can consider investing. Residential. As the name suggests, residential land is a type of real estate that is meant to be used for private housing. Commercial land. Industrial land. What is property and types of property? Property is essentially of 2 kinds: corporeal property and incorporeal property. Corporeal property can be further divided into movable and immovable property and real and personal property. Incorporeal property is of 2 kinds: in re propria and rights in re aliena or encumbrances. What is the difference between land and property? As nouns, the difference between property and land is that property is something that is owned, while land is the part of earth which is not covered by oceans or other bodies of water. What types of property is covered by property law? Property law is the area of law that governs the various forms of ownership in real property, land, and personal property. Property refers to legally protected claims to resources, such as land and personal property, including intellectual property. How much do real estate lawyers make UK? Find out what the average real estate lawyer salary is. The average real estate lawyer salary in the United Kingdom is £61,833 per year, or £31.71 per hour. Entry-level positions start at £49,800 per year, while most experienced workers make up to £87,500 per year. Who holds the title to my house? The title deeds to a property with a mortgage are usually kept by the mortgage lender. They will only be given to you once the mortgage has been paid in full. But you can request copies of the deeds at any time. Property ownership. You can file a special type of lawsuit called a partition action. In a partition action, a court will either divide the property in kind, which means it will divide the property physically among the owners, and or it will order that the property be sold and the proceeds distributed between the owners. What are my rights if my name is not on a deed? In single name cases, as opposed to situations where both owners' names are on the deeds, the starting point is that the non-owner, the party whose name is not on the deeds, has no rights over the property. They must therefore establish what is called in law a beneficial interest. Who is a legal owner? Legal ownership. It is the legal claim or title to an asset or property. Therefore, a person who has legal ownership on a property can transfer it to the ownership to another party. Example, a lender who has lent money for a property is the legal owner of that property. Can a co-owner force a sale of a house? Joint property ownership when one party wants to sell. The law allows any co-owner to fracture the joint ownership via a partition action. Yes. In most cases, any co-owner, even a minority owner, can force a sale of the property regardless of whether the other owners want to sell or not. Can I gift my share of a jointly owned property? Gifting property to family members with deed of gift. Despite the amounts involved, it is possible to transfer ownership of your property without money changing hands. This process can either be called a deed of gift or transfer of gift. Both definitions mean the same thing. Can you claim land after 10 years? Minimum time requirements. Before any adverse possession application can be considered, you must have been using, or in possession of the land, for at least 10 years. In general, this means that the person in possession must have been dealing with the land as an occupying owner might have been expected to deal with it. Does land become yours after 12 years? Adverse possession means someone occupying land belonging to someone else, without permission. If someone does this continuously for a number of years, normally 10 or 12 years, then, in certain circumstances, the land may become theirs. What is the 7-year boundary rule? The 7-year rule. So for example, if you complain to the local planning authority about your neighbor doing something on their land that you don't like, if they've been doing it for 7 years or more, you might not have any luck stopping it. What are the 7 ways of acquiring property? Among the ways personal property can be acquired are by 1. Possession, 2. Finding, 3. Gift, 4. Accession, and 5. Confusion. Possession means the power to exclude others from using an object. What happens to a jointly owned property if one owner dies? If one of the co-owners dies, his share in the property does not pass to the other co-owners but to the person named in the will of the deceased. Like in case of joint tenancy, on death of one co-owner, the share of ownership automatically passes on to the surviving co-owner. What properties cannot be transferred? All interest in property restricted in its employment to the owner personally cannot be transferred by him. Even a right to future maintenance, in whatever manner arising, secured, or determined, cannot be transferred. A mere right to sue cannot be transferred. Can a person transfer a property of which he is not the owner? A conveyance deed is executed to transfer title from one person to another. Generally, an owner can transfer his property unless there is a legal restriction barring such transfer. Under the law, any person who owns a property and is competent to contract can transfer it in favor of another. Can you transfer a property to yourself? It should be noted that you cannot transfer a part of land and/or property to yourself in law. There are multiple ways in which doing so might be abused, and if you are transferring a part which involves property, in order for the part sold to qualify for a new and separate title with the land registry. Is property law and land law the same? Land law is part of property law, where property can be defined in this context as the condition of being owned by way of a legal relationship. Land is known as real property. How do I become a property lawyer UK? How to become a property lawyer. Complete a qualifying law degree or non-law degree followed by the graduate diploma in law. Complete the legal practice course training contract, or the solicitor's qualifying exam post 2021. How do you prove you own your home? Proving ownership. Get a copy of the deed to the property. The easiest way to prove your ownership of a house is with a title deed or grant deed that has your name on it. Deeds typically are filed in the recorder's office of the county where the property is located. What's the difference between a title and a deed? The biggest difference between a deed and a title is the physical component. A deed is an official written document declaring a person's legal ownership of a property, while a title refers to the concept of ownership rights. Can two trusts own property? So yes, California law does seem to allow a trust to be a joint tenant. It has to be the person who transfers it to the trust. So, for example, Abel and Buddy own a property together as joint tenants. Should both spouses be on house title? It is not really necessary because once you are married you will have a right to occupy the house for as long as the marriage continues. The fact that the house is registered in the sole name of your husband will be irrelevant, because the right of occupation is automatic. What is ownership of property? Ownership is the state or fact of exclusive rights and control over property, which may be any asset, including an object, land, or real estate, intellectual property, or until the 19th century, human beings. What is ownership in property law? Ownership can be described as an abstract legal relationship, which implies that a legal relationship exists between the owner and a thing, object, in terms of which the owner acquires certain entitlements and learning outcomes. Can I sell my house if my partner doesn't want to? If one person wishes to sell the house and the other does not, an action of division and sale needs to be raised to ask the court to order a sale. The other person can ask the court to postpone or refuse the sale. What happens when one co-owner wants to sell? A California partition action happens when one co-owner of real property wants to sell but other co-owners do not want to sell their ownership rights. The opposing co-owners have the absolute right by law to divide the property and sell their portion with the legal remedy of partition. Is it better to gift or inherit property? It's generally better to receive real estate as an inheritance rather than as an outright gift because of capital gains implications. The deceased probably paid much less for the property than its fair market value in the year of death if they owned the real estate for any length of time. Can you transfer a property to a family member? Gifting property to family members with deed of gift. Despite the amounts involved, it is possible to transfer ownership of your property without money changing hands. This process can either be called a deed of gift or transfer of gift. Both definitions mean the same thing. Can my neighbor claim my land? Any evidence produced by your neighbor to suggest that they have been in occupation of the disputed land for 12 years or more without objection and which may now entitle them to claim ownership under the law of adverse possession. How do you legally occupy land and remedies? By force, land mafias generally occupy the land abandoned by owners. The remedies: inform the local authorities, revenue department, etc. File a complaint with police authorities. File a complaint in the court. Negotiations also help in case the opponent has occupied the land inadvertently. Who owns the fence between houses? When looking at the plans, the ownership is indicated by a T marked on the plans on one side of a boundary. If the T is written on your side of the boundary, you're responsible for maintaining it. If there's an H, although actually it's two joint TS, the boundary is the joint responsibility of both parties. How do you get property rights? Other than outright purchase of personal property, there are various ways in which to acquire legal title. Among these are possession, gift, accession, confusion, and finding property that is abandoned, lost, or mislaid, especially if the abandoned, lost, or mislaid property is found on real property that you own. Who gets house if one owner dies? Property held in joint tenancy, tenancy by the entirety, or community property with right of survivorship automatically passes to the survivor when one of the original owners dies. Real estate, bank accounts, vehicles, and investments can all pass this way. No probate is necessary to transfer ownership of the property. Who is the owner of property after husband death? Under Hindu law, the wife has a right to inherit the property of her husband only after his death if he dies in state. Hindu Succession Act, 1956 describes legal heirs of a male dying in state, and the wife is included in the class I heirs, and she inherits equally with other legal heirs. Can a co-owner make a transfer without the consent of other co-owners? It is illegal to transfer the property without the consent of other co-owners when they hold the property in the name of all co-owners. Can I gift my house to my children? Gift of a property is usually a potentially exempt transfer, PET. Therefore, after gifting the property, if the donor survives for 7 years, then the children don't have to pay inheritance tax, as the property will fall outside the estate of the donor. You should first take NOC from bank for transferring the property rights to wife's name. 2. After taking NOC from bank, you can execute a gift deed in favor of your wife and deposit the original documents with bank, as it is already under mortgage with bank. Can I give my property to anyone? You can gift a self-acquired property to anyone, as long as you are competent to contract, as per the provisions of the Indian Contract Act. An immovable property can be gifted by executing a gift deed. You need to pay stamp duty on the market value of the property, as on the date of execution of the gift deed. Can mother gift property to son? The procedure to transfer the property from mother to son is by way of gift deed. The registration cost is not as high as in case of registration of sale deed. You need to bring demand draft around R6000 towards stamp fees. Who has right on father's property? The court stated that the property of the grandfather can be held as the father's ancestral property. There are only 2 conditions under which the father would get the property, one being that he inherits the property after his father dies, or in case the father's father had made a partition during his lifetime. Can a son challenge his father's will? Yes, you can challenge it. But before that, some aspect has to be seen, that is whether property was self-acquired property of your father, and if so, then your father has absolute right to execute will under Section 30 of Hindu Succession Act. Can a married daughter claim her father's property? Can daughter claim father's property after marriage? Yes, as per law, a married daughter has every right to claim a share in her father's property. She has as much right as her brother or unmarried sister. Who is the owner of property after husband death? Under Hindu law, the wife has a right to inherit the property of her husband only after his death if he dies in state. Hindu Succession Act, 1956 describes legal heirs of a male dying in state, and the wife is included in the class I heirs, and she inherits equally with other legal heirs. When can a daughter claim father's property? According to Section 8 of the Hindu Succession Act 1956, read with the schedule referred therein, daughters being class I legal heirs, have the same rights as sons to the properties of their father, If the father dies int state, without a will. Who does grandfather property belong to? The grandfather has absolute right to deal with the self-acquired property as he desires. If the grandfather has made a will, the property bequeaths to the person named in the will. If the grandfather dies int state, the property devolves as per rule of succession provided in Section 8 of 1956 Act. Can a witness benefit from a will? A witness or the married partner of a witness cannot benefit from a will. If a witness is a beneficiary, or the married partner or civil partner of a beneficiary, the will is still valid but the beneficiary will not be able to inherit under the will. Can son sell father's property when father is alive? A son can claim father's property when father is alive, in this case after proving his succession. When it comes to self-acquired property, the law does not give any right to son to acquire father's property during his lifetime, unless the son can prove his contribution towards the acquisition of property. Who are legal heirs of mother? Married daughter has equal right in the property of her mother as the son, and in case the mother dies int state, the married daughter inherits her share equally with the son as per the Act of 1956. Under Muslim law, since the law is not codified, rights on the property of the mother are governed by personal laws. Can wife claim husband's parents' property? As per Indian law, wife shall have no lawful claim on her husband's properties, be it self-acquired or inherited, during the lifetime of her husband. To so, it is irrelevant whether husband conveys his title of any property in favor of anybody during the period of the divorce proceeding. Can married sister claim brother's property? Sister can't claim brother's property. Brother's property here means property which has been bought solely by brother's income. But she can claim any ancestral property in brother's possession for which there isn't any will or any other documents which suggests brother has sole right on the property. Who is legal heir for grandfather's property? The grandfather can transfer the property to whoever he desires. If the grandfather dies without leaving any will, then only his immediate legal heirs, i.e. his wife, son, and daughter, will have right to inherit the property left behind by him. How do I remove my sister from my property? In order to remove the sister's name from the mutation extract, as the sister has agreed to remove her name from the land, then you will need to get a no objection certificate of the sister who is also one of the legal heir. You can get no objection of her as a legal heirs. You will have to make application before. wife sell property after husband's death? Yes, she is the title holder. She is free to sell this property without taking any consent from the legal heirs of the husband. Considered as husband's property for the distribution among legal heirs. Wife can sell at any time without any consent. What happens to property when one partner dies? Well, assets that are held jointly will usually pass to the surviving partner. So, for example, unmarried couples might have a joint bank account, and if one partner dies, the remaining partner can still continue to use the money in the account. What happens if father dies without will in India? Since your father died inte, that is, without making a will, all the legal heirs, including you, your brother and your mother, will have equal rights over the property. If he had made a will making your brother the beneficiary of the property, you would have had no legal right over the said property. Can daughter-in-law can claim father-in-law property? A daughter-in-law has no right in the ancestral or self-acquired property of her in-laws. Thus if a father dies inte, a daughter has an equal right in his property along with her brother, but the daughter-in-law has no right in the property of her father-in-law till the time her husband is alive. What if witnesses to will cannot be found? One way to do this is to have witnesses sign a self-proving affidavit at the execution ceremony. Without the self-proving affidavit, if a witness cannot be found or has since passed, it becomes harder to prove to the judge that witness signatures are authentic, which results in added expenses for the testator's family. Who keeps original copy of will? The most likely person to hold the document is the executor selected in the will. For example, a client names her adult daughter as the executor of her will. The client gives her adult daughter the original will and tells her that she will need to bring this to the probate court upon her death. Is a handwritten will legal? Self-written wills are typically valid, even when handwritten, as long as they're properly witnessed and signed or proven in court. A handwritten will that is not witnessed is considered a holographic will. Not all states accept holographic wills. Can father deny son's property? A father can disinherit his son from his self-acquired property only, and not from his ancestral property. Self-acquired property refers to property that is not inherited but is self-made out of one's own funds and resources. A property acquired through a gift deed or through a will is also self-acquired. Can I claim my father's property? According to the Hindu Succession Amendment, Act 2005, you have the same right over your father's property as your brother's. In case of ancestral property, you have a right to it by virtue of birth and can make a claim over it. What are the rights of second wife? In case the second marriage takes place after his divorce with the first wife or after the demise of the first wife, the second marriage will have legal sanction and the second wife will have every right in her husband's ancestral and self-acquired property, and fall under the Class 1 heirs of her husband. How do you transfer property from father to mother after death? Apply for mutation of property in your mother name. Enclose father death certificate. Gift deed or relinquishment deed by other legal heirs. If no objections are received, property would be mutated in mother name. Your mother can also apply for letters of administration from court. What is inheritance property? Inheritance is a convention of passing or rather transferring properties, titles, debts, rights, and obligations to the legal heir of a person upon his/her death. It can be done by either a will or through laws of succession. Legal owners have to go through legal formalities to acquire the ownership of their property. Can a mother give all his property to one child? Your mother is the absolute owner of the property. She can transfer the property as per wish. After her demise, you can challenge the will if she execute in favor of your brother alone. If he is not probate the will properly, it has only scrap value. How do you transfer a house from husband to wife after death? However, in the case of death of a spouse, the property can only be transferred in two ways. One is through partition deed or settlement deed in case no will or testament is created by the deceased spouse. And second is through the will deed executed by the person before his/her last death. Can divorced wife claim property? After divorce, a wife cannot state a claim in your property as a matter of right. The wife cannot claim ownership in the flat, however, it is just that she cannot be evicted forcefully from the matrimonial premises. 4.9 on 5.0. If any share certificate is in place, then she can claim her share. Transfer my property to my sister? You can make a gift to your sister. This will involve execution of a gift deed which will have to be registered with the sub-registrar and would attract stamp duty which would be payable on the basis of market value of the residential property. Can a father disown his daughter in India? Even if the parents evict a child from their house, there is no legal concept of disowning an adult child in India. In case of a self-acquired property, the parents can disinherit a child by cutting him out of the will. How do I split my parents' property? Give the house, the land, or the business to just one child and make up the difference with a monetary share for the others. Alternatively, stipulate that the asset be sold and the proceeds divided evenly. That way, the one who really wants the asset can buy the others out. Who are legal heirs of grandmother property? Mother, son of a predeceased son, daughter of a predeceased son, son of a predeceased daughter. How much property wife gets after divorce? The wife will be authorized to a 50% share of the husband's property, including his ancestral property. She also has the right to reside in the couple's marital home and to be provided for and maintained by her husband. What happens if my husband dies and the house is in his name? If you and your deceased spouse own a home as joint tenants with a joint bank account, the ownership of the property will be passed straight to you. You can then remain in the home or sell up if you cannot afford any outstanding mortgage or simply fancy a change. Does a married daughter have any rights on her father's property? Can daughter claim father's property after marriage? Yes, as per law, a married daughter has every right to claim a share in her father's property. She has as much right as her brother or unmarried sister. Can a married daughter claim father's self-acquired property? But in 2005 the law changed and now the Hindu law states that the daughters and sons have equal rights on father's self-acquired property and also on ancestral property irrespective of their marital status. A Hindu daughter can claim her share of the property after the death of the father. What voids a will? A will is invalid if it is not properly witnessed or signed. Most commonly, two witnesses must sign the will in the testator's presence after watching the testator sign the will. The witnesses typically need to be a certain age, and should generally not stand to inherit anything from the will. Can mother transfer son's property? As per the Transfer of Property Act, ownership in immovable property can be transferred effectively through a duly stamped and registered conveyance deed, otherwise it won't be a valid transfer. Such a decree will create ownership of mother on the share of son and does not require to be registered. Can father sell son's property? No, ancestral property cannot be sold without consent of successors. In case of major and in case of minority you might have to take permission from the court. And if property disposed without consent can be reclaimed. What makes will invalid? Failing to take account of all the money and property available. Failing to take account of the possibility that a beneficiary may die before the person making the will. Changing the will. If these alterations are not signed and witnessed, they are invalid.
We are ending our video here. Again, see you with a new video with the basic concepts and knowledges relating to law engineering. Thank you.